But if for some reason we're not able to get to all of the questions, please do not hesitate to reach out to me after this presentation. I'm always happy to answer general questions. I can't address specific situations unless I'm engaged. That's my disclaimer, because I'm an attorney and we always have to include them. So you are here and you are in the right place if you're concerned that perhaps there might be a mistake within your planning. This is not meant to scare you. It's just that there are, unfortunately, a number of situations that come up on a regular basis where when someone comes in, sadly, often in a crisis situation where someone has perhaps suffered a health crisis like a stroke, and we're worried about nursing home admission or discharge home and trying to deal with care needs, that at that moment, we're looking at the existing planning and we identify that what they have in place does not work or will not work. So we're scrambling, trying to take care of it while the family's already in crisis, in dealing with a lot of trauma and emotional distress. So my goal with these is always to say, if nothing else, take today, sit down, pull out whatever you already have in place, and call your attorney to sit down and review it with them. Most of us offer review meetings. Not all attorneys do it without a charge. I sit down with my clients and do their reviews without charging them. I only charge if we do additional work. Ask your attorney. It's well worth sitting down to make sure that things still work. With the caveat that if the person who drafted your planning is not an elder law attorney, you might want to sit down with an elder law attorney. Lifespan maintains a directory of people in the community. So, you don't have to come to me. You don't have to come to Harris Beach. I would love it if you did, of course, but you can go back to Lifespan and they will give you a whole list of vetted law firms in the area that offer elder care services. So I would encourage you to make sure you do that. And if you are starting out with someone new, ask about their history, ask what they've done in their experience. I'm laughing because, as you're going to see on one of our final slides, it's Lifespan's 50th anniversary this year, and I turned 50 this year myself. I can't believe I've been practicing 23 years, but time flies. And, you see a lot, you experience a lot. You want to know what the person you're working with has done and what they've gone through. So before I get into the top mistakes from past discussions and past presentations, I have paid attention to the feedback and I want to make sure that we go over some of the basic things. Thanks, Mary Rose. So for anyone who doesn't have their chat open, the elder law attorney list is right on the Lifespan website. So we're going to talk about what do people need versus what might some adults need. Okay, so everyone, in my opinion, needs a power of attorney and a healthcare proxy, and they might need a will. You might say, why would you say they might need a will? Because in New York State, like most states, if you don't have a will, our statutes take care of them for you. So there's a default that's already been set by our legislature, and it's been on the books for a very long time. But that may not match with what you would want to happen with your property. So it's still a good idea to sit down and talk to someone. Okay. The other piece with the will is that what you have to understand these days, most wealth in the United States is very often not individually held where it's going to go through probate. Probate, which is, as attorneys, we talk about probate as the beginning of an estate administration process. Sometimes you hear probate referred to as the whole estate administration process after someone passes away and going through the whole court proceeding. Probate really is just having your will admitted to the court. And we'll talk about that a little bit more. But most wealth these days is held in accounts that have beneficiary designations. If you look at most individuals, aside from your home, probably the largest asset you have is a retirement account, whether it's a 401k, 403b, you've rolled it over into an IRA, you've converted it to a Roth IRA. That tends to be where most of the wealth is. And those types of accounts have beneficiary designations. Your will doesn't touch them. So you need to make sure that you're working to create a plan, not just a document. So I'll keep coming back to that. And then sometimes people are going to want a more expansive power of attorney. And I'll talk about it when I get to the power of attorney. I left this language on here. We no longer have to have a separate statutory gifts rider, but you want to have modifications within your power of attorney that deal with gifting, so that if you lose capacity, whoever you have chosen, whoever you've entrusted with that authority to manage things for you, can actually do what needs to be done and isn't relegated to just bill paying. Okay. And then for some folks, a revocable or living trust can be helpful. It's not something everyone needs, nor is an irrevocable trust something everyone needs. Irrevocable trusts are what we use most often for Medicaid planning. Okay. And I'll talk about that. But what you have to understand is an irrevocable trust is just an umbrella term for many different types of trusts. Okay, so it can be a life insurance trust. There are all kinds of cutesy names in the estate planning world, lots of acronyms that we use. You may hear CUPERT, you may hear SLAT, Inter Vivos Q-tip. There are all these crazy acronyms that get used, but each of those is a type of an irrevocable trust that can be set up with a skilled estate planning attorney. Okay, but it has to be based on your specific needs, and everyone is unique. Okay, so what are we going to talk about now? Let's see if I can get the slide to advance for you. So power of attorney, these are the key pieces. I focus most, and I will tell you, in my opinion, this is the most important document that anyone who is over the age of 18 can have. Okay, you want to name someone who can manage finances for you should you lose capacity. And it's not just bill paying. You want someone who can actually transfer assets out of your name. You want someone who can make gifts on your behalf. And you want someone who can move things so that you can qualify for government benefits if necessary to pay for long-term care. Most of the nursing homes in our area are upwards of $14,000 per month. So even for someone who has saved significantly throughout their lives, that starts dwindling very quickly when you are paying $14,000, $15,000, $16,000 per month for care. And if you're trying to stay at home, 24/7 care at home is even more expensive than that. So there really does need to be the ability to name someone that you trust. The other thing you want to keep in mind is that under our laws, the power of attorney has to be signed by both you as the principal, the person who's creating it, and your agent. And then you have to decide if you want more than one person to be able to act, if they can act together, or they're allowed to act separately. So it's a big consideration, especially for a lot of folks, they name 2 adult children. Well, if one is living locally and one is down in Florida, you may not want to force them to act together. So there are practical considerations that come into play here. I see that there's a question in the chat. Is there a viable life insurance plan that can also pay for long-term care? Yes, there are types of life insurance that have long-term care riders. They're typically referred to as hybrid plans. And financial advisors who are licensed to sell long-term care are typically the best people to talk to about that. I work with folks. If you have someone that you're already working with, you should ask them. Not all financial advisors are licensed to sell long-term care insurance. You want to make sure you're working with a specialist who understands all the nuances. And the other piece to that is that not everyone is a good candidate for one of these types of policies, because you still have to meet medical underwriting to purchase life insurance. So if it's something that you want to look into, the underwriting for long-term care on its own, long-term care insurance on its own, continues to get more difficult, as does life insurance as you're getting older. So don't hesitate, don't wait to have that conversation with the advisor in your life. And if you need referrals, again, you want to reach out. But if you are already working with a certified financial planner or an RIA, a registered investment advisor, they will have someone on their team, even if they don't do it themselves, that can assist you in looking at all of your options. Okay. So whoops, okay, sorry, I want to go back. I mentioned that you want to make sure within the power of attorney that you include modifications that allow for gifting. So the law has changed now 3 times since 2009. So if you've got a power of attorney that predates 2009, my suggestion is you definitely want to review it, but you probably want to update it. Up until this year, when the new form came into effect in June, from 2009 until June, we had a power of attorney that limited gifting without a separate rider attached to it to $500 total, not per person, total in a calendar year. So now the statutory minimum has been bumped up to $5,000, but that's still pretty minimal if something catastrophic happens. Right? You may be able to actually facilitate family gifts for birthdays and, the holidays, graduations, weddings, whatever celebration might come up with that $5,000 gift. But you're not going to be able to allow your agent to do tax planning. You're not going to be able to do crisis planning to qualify for Medicaid benefits. Someone needs to be able to move assets out of your name. So do yourself a favor and make sure that you look at this power of attorney. And you do not want the bare bones form that you can go online and find. It is very, very basic. Okay, so I'm telling you that right now. I'm also going to tell you that there are certain canned financial products that you can purchase online from well-known self-professed finance experts. I can think of one whose first name is Susie. Do not trust those. They are not geared to individual states. They're a generic form that's been produced by that particular company or individual. It's not the individual, they're not an attorney. And they have not been vetted by experienced attorneys in individual states. So don't waste your money on those. Okay, I cannot be any clearer. Meet with your attorney, or again, you can go to the Lifespan website and find a list of qualified elder law attorneys, and you can reach out to one of us to review this and make sure that you have the proper document in place. Okay. So, now, the other crucial document that you should have in your repertoire of estate planning documents is a healthcare proxy. Okay. You will hear different names for this document. If you are a snowbird, Florida has medical powers of attorney, right? Depending on the state. In New York, our form is called a healthcare proxy. Sometimes people will talk about a living will. So you'll see on this slide, a living will is not the legal document. It's just an expression of your wishes. And it can be very detailed and say things that you would like to happen. It can be more often very detailed in terms of things that you do not want. So you do not want artificial, you do not want artificial feeding and hydration. You do not want intubation. You do not want resuscitation. These are all things that can be included, but it's very personal. So with us, I can tell you that at my firm, we will offer our clients a choice. I typically include some living will language in my usual standard healthcare proxy, and then we customize it together so that it matches your wishes. Some people just have a document that says, my agent knows my wishes. The whole point of having these discussions when folks come in for a planning session with me is so that we can actually have a conversation around end-of-life decision-making, because your providers are supposed to go to you for all of your medical decision-making. The healthcare proxy, the person that you name as your agent, as your proxy, is there in the event that you can't speak to your providers. And they really need to know your wishes to the extent you're able to think about this and make a decision. I know for some people, you absolutely are not able to have these conversations. It just touches a place inside that you can't go there. In those instances, we do not include any specific language, because I would never want a client signing a document that doesn't actually match their thoughts and their desires. But to the extent you're able to have this conversation, it's crucial. there is a local doctor who's very involved in the nationwide end of life, movement in terms of preserving dignity. And her name is Patricia Bamba. I always like to share Dr. Bamba's holiday tradition, especially as we're in November. She, as a rule, makes it a policy that no one gets their Thanksgiving dessert when the family is together until they've gone around the table and talked about their end-of-life wishes. Now, I understand that might be a little macabre, but when else is the family all together and actually in a place where you can have a conversation? Usually when you've got a big family gathering, everyone's all over the place and it's a little bit crazy. When you're confined to that Thanksgiving table, it really is a perfect time to have these conversations, and it doesn't have to be long and drawn out. So take it for what it's worth. I can tell you that my family has resisted, but they're now used to it since I've incorporated that tradition. And, now we're at the point where we kind of have some sort of dark jokes as we go around the table and go, yep, you still feel the same way? Okay, great. I'm it. I'm the one who's going to make that decision for you. And I'm not making light of this because I can tell you that I got a call earlier today for one of my long-term clients who just found out that, things are not going well for his wife. So please don't think I'm making light of having to honor these decisions in any way, shape, or form. But it's really crucial that your agents know how you feel and what you want so that they can honor your wishes. I'm looking in the chat right now. If your spouse is POA, she should have unlimited spending capabilities without further legal action. Depends on what the power of attorney says. You need to make sure your power of attorney actually reflects your wishes. So moving on, I said that everyone might need a will. Okay. Your will, and I mentioned this before when I was talking about how wealth is held, your will directs where your individually owned property passes upon your death. So it doesn't touch joint assets. Okay. If you have a joint bank account with rights of survivorship, your will doesn't matter in the least. If you have an investment account, most financial advisors, certainly if you're with one of the bigger brokerage houses, they will often suggest to you, do you want to make this account transfer on death and name beneficiaries so it doesn't have to go through probate? Again, if there are beneficiaries on that account, your will doesn't matter. Even if your will mentions that account specifically and includes the account number, which I don't recommend, doesn't matter. You've already taken care of that by adding that beneficiary designation, and that's going to trump what's in your will because those accounts are governed by the contracts that you have with the custodian. Okay, so life insurance, retirement accounts, as long as there's a named beneficiary, we follow the contract, we follow the beneficiary designation language. So your will is a good thing to have, but it may not touch that many assets, especially if you're married or in a relationship where you and your partner have significant things that are owned jointly. Okay. And if you don't have a will, then I mentioned previously, New York statute controls, and it's called intestacy. So if you pass away with a will, you have died testate. If you pass away without a will, you die intestate or intestate. Okay. So we will typically, when we're doing a planning package for folks, prepare wills. And I will tell you that I believe that most individuals should have a will. There are protections that can be provided within a will. We can create ongoing trusts for a surviving spouse or a minor child or someone who's disabled, which I'm about to talk about. There's a lot that can be done via your will in conjunction with beneficiary designations. But you don't want to simply rely on your will taking care of everything because in and of itself, it doesn't touch that many assets. That's why you need a coordinated plan as opposed to a document. And very often when folks call, they'll say, oh, I need to update my will or I need a will. Probably, but you also need a power of attorney, a healthcare proxy. Your beneficiary designations need to coordinate with whatever your wishes are. And we need to make sure we look at all of your assets so that we identify those assets that do have beneficiary designations in case those designations need to be changed. So when you call an attorney and they tell you that we need you to fill out a questionnaire, that's why. We're not just trying to pry into your personal information, I promise you. But we need to know what you have, not only to determine whether we have to do tax planning, long-term care planning. We need to know what's out there so that we can help you make sure your plan works when it's needed and not rely on chance and hope that it will work. Okay. So, trusts. All right. Trusts, as a basic rule, are simply agreements. Whether it's a living trust or, whether it's a living trust, which is revocable, or an irrevocable trust, it's simply an agreement. So it's created during your lifetime, then it's an inter vivos or inter vivos trust. So you've got a grantor, a trustee, and there are individuals who are the beneficiaries. It might only be one beneficiary. It's okay. Those are the main parties to it, okay? If it's created by a will, it's called a testamentary trust, your last will and testament. It's a testamentary trust, okay? So in that instance, and that's where I said the will can be very beneficial, you're creating a trust that actually doesn't exist until after you pass away. What has to happen is you've got to pass away. Your will has to go through the probate process where the surrogate's court says that it's a valid will. And at that point, the judge appoints your executor, okay? So when someone calls me and says, oh, I'm my mother's executor, and I say, I'm so sorry, when did she pass away? And they say, oh, she hasn't passed away yet. Like, okay, so you're only a nominated executor until you've actually been appointed by the court. There is no automatic appointment. Just because you're named in the document does not give you any authority unless you go through the court process. So just as the executor has to be appointed by the surrogate court judge, so does the testamentary trustee. And then once you've been appointed by the court, then the attorneys who are administering the estate with the executor and the trustee can go out and get a tax number for that trust, because trusts have to have their own tax ID numbers if they're going to be testamentary or irrevocable. And then you can fund the trust. So it gets a little confusing for folks when we talk about setting up a trust under your will, because they're like, well, where is it? Do I need to go to the bank? No, it will not exist until after you pass away. But the shell is there in the document and the guidelines are there so that it can be created and funded at the appropriate time for the people you're trying to take care of, whether that's a surviving spouse or a minor child or a disabled loved one, okay? And then you'll see here on the slide, there are multiple purposes for having a trust. Very often when we're dealing with real estate in multiple states, we will use a living trust. Because if you just own property, real estate that is, individually, you have to then go through a court proceeding in each state where the property is owned. So you would have original probate here in New York, and you would have an ancillary administration or ancillary probate in all of the other states. So it can cut down on administrative costs and delays. So sometimes people just do it for privacy. I do a lot of living trusts for individuals if they are not married, don't have children, and the people who would typically inherit from them, and this is where we go through your family tree. It could be distant cousins who you have no contact with anymore. But under our statutes, the people who would inherit in intestacy, remember I said intestacy if you don't have a will, the people who would inherit in intestacy are actually entitled to notice and a copy of your will as part of the probate process. So to avoid all of that and the delay and the cost of tracking people down if we don't know where they are, we will do a living trust, because with a living trust, whoever is named as the successor trustee can immediately step in and start managing assets when you pass away. So again, it's not for everyone. It's not necessary for most couples who own assets jointly to go to that extra level of creating a trust and putting jointly owned assets in the trust. So you really want to make sure that whoever is talking to you about your planning gives you all of your options and explains why they're recommending what they're recommending. You don't see it as much anymore, but in the past, there were what we as practitioners would call trust mills, attorneys who prey on folks and do free seminars and tell you that you absolutely have to have a living trust, or, oh my gosh, your family's going to lose so much money to the probate process. It's really not the case here in New York. The maximum filing fee to go through the surrogates court here in New York is $1,250. That's the maximum. And that's if the probate estate, remember those individually owned assets are $500,000 or more. Okay. So in other states like California, that's a place where it is very commonly set up as the main planning tool. Well, in California, their probate fees are based on a percentage of the value of the assets. So there's really not a cap. In New York, we have a cap on our filing fees. Let's see. I'll answer that question in just a second. And then the other thing, if you take nothing else away from this, because I still unfortunately am seeing folks come in who say they've been to seminars and been told that assets they put into a living trust are protected. With a living trust, that is revocable. If you create it, you are typically the grantor, the person who creates it. You're typically your own trustee, and you're typically the beneficiary. And you can change your mind at any time and pull those assets out. If you can reach into the trust and touch an asset, that means that that asset is available to all of your creditors, whether it's for long-term care or anything else. So don't ever believe that a living trust protects your assets in New York State. I know in some other states, it's an option. It is not an option in New York. So if you're a New York resident, you cannot have a living trust that's based in New York and receive creditor protection. If you're doing planning to save assets, whether it's for long-term care or other asset protection purposes, it has to be irrevocable. Okay. I see we have a question. How do you leave money for funeral services where the will takes time to settle? Best thing you can do, and we have 4 full-time paralegals in our Rochester office. That's all they do. We always tell folks, set up a pre-plan with a funeral home. Do it now. You can leave it as revocable. You don't have to make it irrevocable. If it's revocable, you can change your mind at any time and pull it out. But go make your own choices now. Meet with the funeral director. Have everything laid out. Your family will thank you for it. It is already, it's already such a horrible time when you lose someone close to you to have to try to make those decisions. You are not in any frame of mind to do it. I can't tell you how often families say to me, adult children especially, that was the nicest thing mom did. That was the nicest thing dad did, because we were so devastated. And to know that that was taken care of and we didn't have to make choices, or we only had to make a few choices, it's huge. Right. And then depending on your planning attorney, they may also give you some additional documents like helping plan for services if it's something that you want. Okay. Thanks, Mary Rose. Absolutely. And tell someone in your family that you did prepay and pre-plan and where it is. So the difference between living or revocable trusts and irrevocable trusts is that an irrevocable trust is exactly what it sounds like. You create it, you give up control, and you can no longer cancel it or take back what you put into it. That's how you protect assets. And we'll talk about that a little bit more. The other huge trust that I want to talk to you about is a supplemental needs trust. So this is a variety of trust. Supplemental needs trusts are specifically geared for individuals with disabilities. They are allowed by federal statute, so federal law, as well as state law. Okay, the big difference is under federal law, you will hear special needs. New York State, under our legislation, calls it supplemental. The idea is that these trusts are there to supplement whatever can be paid for by government benefits and whatever little resources and income the disabled individual has for themselves. So there are various types of supplemental needs trusts. So yes, they can be created during life. So you can, just like with traditional living trusts and irrevocable trusts, supplemental needs trusts, if created during lifetime, are a variety of irrevocable trust. They're created, the funds go in, they're for the benefit of the person who has an intellectual or developmental disability or has suffered a catastrophic injury. Whatever caused the disability does not matter. It's, does that person meet the disability standard? If so, they can have a supplemental needs trust. And whatever goes into that trust cannot be forced to be used for their needs. So it's able to sit and supplement what the government pays for. So this is a huge benefit to folks. Okay. So if it's a first party trust, it's created with the disabled individual's own money. We try to avoid that because those trusts are required to have what's called a payback provision. So when they pass, whatever's left in that trust has to go back to New York State and any other state that provided benefits during their lifetime. There are some other specific rules around that, and it goes way beyond the scope of today's presentation. But the reason I'm telling you this is because you have the ability through your own planning to avoid your loved ones being forced to create a first party trust. So what I recommend as an elder law attorney is that all of my clients allow for third party supplemental needs trusts under their planning. So when it's a third party trust, that's you putting money aside for someone else. They never own it. And because they never had an ownership interest or control over that money, those assets, those funds, there's no payback requirement when that person passes away. So it's complicated, but it's so beneficial because assets in a supplemental needs trust don't count against a Medicaid applicant. They don't count against someone who's on Medicaid. So even if someone's already on benefits, if, for example, a parent or grandparent passes away but says, I'm not leaving anything outright to my disabled son, it's going into a third party SNT. So when you hear SNT, it's standing for Special Needs or Supplemental Needs Trust. By doing that, none of those funds are available. It won't disqualify the person who's already receiving Medicaid from anything. And now there are funds that can help with a living situation. They can help get better options if they need equipment, right? What the government pays for can often be pretty bare bones, but the funds in the Supplemental Needs Trust can be used for non-medical needs, and they can also supplement medical needs that aren't covered by the government. So for example, Medicaid pays really lousy dental benefits for participants in the program. If there's a Supplemental Needs Trust, it can allow for some better dental work. And if you've ever dealt with dental issues, you know, it's life-altering to know you can go to a good dentist and have whatever it is taken care of. Okay. So now that we've covered the basics, what are, in my purview, the top 3 elder care planning mistakes? Number 1 is always a faulty power of attorney, because with a power of attorney, your agent can step into your shoes and do anything that you could do with your assets and your income sources. The only thing they can't do on your behalf, if it's drafted comprehensively, is sign a new will. That's not allowed under the statute, but that's the only thing. They can move assets, they can create trusts, they can deal with estate benefits, they can do anything for you but for sign a new will. Number 2 is failing to protect a sick spouse after a diagnosis by not creating a testamentary, remember, under the will, supplemental needs trust under the will of the well spouse, right? We want to protect our loved ones in the event of a disability. Sometimes you know that the disability exists. Otherwise, you're just protecting in case something should happen, but you have that ability. And 9 out of 10 wills that I review do not have a supplemental needs trust under them. And it's very easy to include it. I do it as a matter of course. A lot of attorneys do not. So it's something you can look for in your own documents. They're very easy to include. And we've had, where I get upset is this type of option has existed in our statutes in New York State since 1992. So this is not something new. For almost 30 years, this has been specifically available. Clear language. I want to include a supplemental needs trust. Here's the statute. Boom, it's literally laid out in the statute, the language that needs to be used. And then those of us who do this for a living have added on to that and amplified what is available in the statute, but it's there. So there's no reason for attorneys not to include them for you. And then the final one that sadly we see all the time is people trying to save, and I absolutely understand the desire to save money, but people using a deed rather than an irrevocable trust to try to protect real estate. And we'll get into why that can be really, really dangerous for so many folks. So again, look at your planning. If you have a deed that's already in place, you might want to be revisiting that. And you certainly want to be, as I mentioned at the beginning, if nothing else, pull out your existing planning documents and schedule a review appointment with your planning attorney. And if they're not a planning attorney, go to the Lifespan website and find an Eldercare attorney to do a review with you. Sorry. Before I move on, there's a question. As the POA for mom applying for Medicaid in the nursing home, is it better to have an irrevocable burial trust, or can you just make out a pre-planned funeral with the funeral home? So the pre-plan needs to be made irrevocable if you're applying for Medicaid. For this year, I'm going to talk about supplemental needs a lot more as we go forward, so don't you worry. But to answer the question about the pre-plan for a Medicaid application, as part of the Medicaid process, there is a limit when you apply for Medicaid to what you can have in your assets. Okay, there's an asset component and an income component. So for 2021, the person who's applying for Medicaid assistance can't have more than $15,900 in his, or in this case, her name, with few exceptions, right? So a prepaid burial, which is a pre-plan with a licensed funeral home, will not count towards that $15,900 as long as it's irrevocable. If it's revocable, then whatever the value of that pre-plan is part of the $15,900. So absolutely, if it already exists, you want to call the funeral home and have them make it irrevocable. They're wonderful to work with. We're really fortunate in the Rochester area. We have great funeral homes. The directors are always happy to do things on the fly. They understand Medicaid is such a huge necessity, and they will do everything in their power to make it happen quickly for you. So you always want it to be irrevocable when you're on that application, threshold. Okay. Before you know you need to apply for Medicaid, it's okay to have it be revocable, because you might change your mind. You might decide to move. You might decide you want to go somewhere else. But when you know you're headed towards Medicaid, call and make it irrevocable. Okay. So let's talk about the power of attorney. I promise I'm going to talk more about supplemental needs trust when we get to mistake number 2. So again, if you have a power of attorney, check the date. Okay. Was it after September 2009, right? Now you've got to worry about what are the specific provisions in there. So I told you the law changed again this year, but now for a power of attorney to be effective, both you, the principal, and your agent need to sign. Pre-2009, you could sign a power of attorney and your agent didn't even know they were named. It used to be really disconcerting, because I have been practicing that long, to get a call from someone telling me that their parent was in the hospital. And I'd say, okay, well, all right, you're the power of attorney. And they'd say, what do you mean? Why is it me? Why isn't it my brother? And I'd say, well, my notes say that your parent wanted you to be the agent. They're like, I'm not capable of doing that. So now at the very least, there's that notice piece, and you have to agree to take on that role. What I see, sadly, is parents are nervous about giving up this authority, which I understand. It is a control factor, which is why you only want to name someone that you trust implicitly. The way the power of attorney law works is that once it's signed, that power of attorney is effective as of that date. However, if someone's acting as your power of attorney agent, they have a fiduciary duty. They are there to stand in your shoes and do what is right for you, not what they feel like, not what they think is best, but what you would do and what's best in your interests. So while it's effective immediately, there's no reason for anyone to be actually touching anything or doing anything with your assets unless there's an actual need. Okay, so where we will often see problems is that there is no additional gifting authorized. I mentioned before that the new law has bumped up the minimum that's allowed under statute without doing anything more to $5,000 in a calendar year. But that may not be enough. Certainly if there's a crisis or the folks in power really do come back and decide to lower our estate tax exemption amounts, you know, it seems like we've dodged a bullet, at least in the short term with that. But I have a lot of clients who are very, very concerned. And we made sure that there was gifting authority because someone needs to be able to move assets and do planning on their behalf if they lose capacity. They don't want anything to be stuck because no one has access. You know, and another piece here, I know many of the folks who come to these presentations are retired already, but if you're still working, especially if you're in a family business, you absolutely need to make sure that you have a comprehensive power of attorney. And in addition to the power of attorney, having business powers, you want to make sure that you've got someone else on the bank accounts. I went through a really sad situation with a client earlier this year where their father had involved other people in the business, but never put anyone else on the bank accounts. And he passed away suddenly, and they were faced with trying to make payroll, and no one had signing authority. So it was a real mess. So if your family falls into that category, and there are many, many in our area, please make sure that your planning is up to date. You know, do it for your loved ones and do it for your employees. For those of you who have those existing documents, pull them out. Who did you name as your agent? Planning attorneys recommend that you do reviews every 5 to 10 years. I actually recommend every 3 years to my aging clients because circumstances can change so quickly. You know, I know within my own family, my mom is the baby of her brothers and sisters, and sadly, we've lost 3 in the last 18 months. So things happen quickly. Make sure that the people that you've named as your agent and as your successor agent, are they still with us? Do they have capacity? Are they starting to have issues of their own that would prevent them from helping you out? Okay. If something happens to you and you lose capacity and you don't have an agent who's capable of stepping in to serve, more often than not, it ends up that we will have to do what's called an Article 81 guardianship. That's under the mental hygiene law. And we have to go into Supreme Court and petition to have someone appointed to manage your affairs for you. And it may or may not be someone that you would want involved. You know, here in Rochester, and Lifespan happily is one of the entities that can fill that role. But they don't have, and Mary Rose, I know you could speak to this because you know so much about all the wonderful programs that Lifespan offers, but there just isn't the manpower to step in and take on these roles. So you want to name someone that you trust to be able to do this. No, if you have joint assets, oh, sorry, I missed something, but if you have joint assets, you still need a power of attorney. When you own joint assets, you have control over your one half. And you have no legal authority to do anything with the other 50% of those assets, absent a power of attorney. Doesn't mean that some clerk might not allow you to do it, but the Medicaid caseworkers here in Monroe County know to look at the power of attorney and see what the authorities are, and they can come back and challenge actions. And courts can challenge actions, and other beneficiaries can challenge actions that are taken, especially if it's a second marriage situation. So you have to have a power of attorney. You can't assume that because you're married, you're allowed to do these things. And I'm sorry, Mary Rose. Oh, at what age should a married couple meet with an attorney for eldercare planning? Well, if you're over 18 and you're married, you want to sit down with someone and make sure that you've got appropriate documents in place. Typical times are when you're looking at retirement or you received an inheritance, kids are moving out of the house, you've just had a grandchild. Usually there's some life event that sort of prompts the discussion. But if you're thinking about it now is a great time to do it. There's no magic time, okay? And then here's the key thing. Just because you have the power of attorney in place doesn't mean it has all of the needed provisions, okay? You want to have an elder law attorney review this, okay? It's very sad to me when something happens. So I'll leave this slide up here while I'm talking, but this is an example that I actually had in my practice. I've changed names, of course, but it was for a married couple. They had done planning back in 2007, and they thought everything was in place. You know, they didn't even remember who had done their planning. But the wife developed dementia and had to be placed into a skilled nursing facility. So her husband called me and said, okay, I'm ready to do a Medicaid application. And I said, well, I need to review what you have in place. And he said, no, I just need you to help with the application. We already did our planning. It's all set. But the problem was the power of attorney, because it was older, limited. It had specific language that limited gifting to $10,000 per person per year. And it was debatable whether or not she had the ability to sign a new power of attorney. Ultimately, we were lucky and able to do it, but it really caused a lot of angst. Okay. And so again, here's another example. Check the agent status and make sure you've got a successor named. So this happens very commonly. Married couple, they name each other, but they're like, oh, we don't really need a successor. We just trust each other. We're not sure we could come up with anybody else. Jane develops dementia, and now John dies suddenly. Jane doesn't have anyone who can act on her behalf. And if she doesn't have enough capacity to sign a new power of attorney, she could end up in one of these Article 81 guardianship proceedings. And I can tell you that even if the family all agrees on who should step in and be that agent, it's thousands of dollars just to get through that court proceeding. And it's time consuming, because even though you bring them on by what's called an order to show cause that's supposed to go quickly, there's statutory timeframes that have to be respected. So it's not something that can be done overnight and awarded by a judge. So do yourself a favor and make sure that you are meeting with someone and making sure things work. Okay.
So there's a few questions in chat.
Yeah, so I'm trying to go up to see if sorry. Okay, I think if I missed one, Mary Rose, let me know. But do I recommend parents put an estate or house in children's name for estate planning? Nope, and that's mistake number 3, just putting the house via deed into your kids' names. You want to use a trust if it's appropriate, and we're going to talk about that in more detail. Can a nursing home force the POA to make payments for resident until they qualify for Medicaid? In New York, children are not responsible for, there, I was trying to clear the chat thing. Oh my gosh, sorry. In New York, children are not responsible for their parents' medical bills. However, if you're the POA for a parent who's applying for Medicaid, you do still have a financial commitment to the nursing home. And typically, and hopefully you're working with an elder law attorney, they should be advising you and giving you an estimate of what the income contribution will be once your mother qualifies for Medicaid. It's called the NAMI, Net Available Monthly Income. And there's a whole budgeting that goes into place for that. So even though they can't bill you full private pay once the Medicaid application goes in, you should still be contributing your parents' income. It shouldn't be going towards anything other than their nursing home payments, or you could be violating the admissions agreement if you signed it. So that's a really detailed consideration analysis, and you want to be working with an attorney on that. So, but generally speaking, you want to be paying over income every month. And yes, you have the obligation as the POA to do that because you have control of the assets. Okay. So let's get back to the slides. So if you're worried about having a faulty power of attorney, you want to meet, as I said, every 3 to 5 years, meet with your attorney. Make sure that your planning documents are keeping pace with your life changes and with law changes. You know, there's no set time frame for when the legislature is going to come at us with something new. Okay. Update is needed. And then I put this one on, call your attorney first, not the financial advisor if something catastrophic happens. And this is not me slamming financial advisors. They are a key part of the planning team. But sadly, I have seen far too often families call their financial advisors And then they work with the financial advisors for 12 months or more to structure payments or buy an annuity and come up with ways to access cash inside retirement funds to pay for long-term care needs. Here's the deal. Under the Medicaid rules, if you have assets inside an IRA and it's in what they call pay status, you're taking your minimum required distributions. And even if you're under 72 now, there is a table that can be used where you can start taking distributions. If you're taking those distributions every year, the balance inside that IRA, I don't care if it's 200,000, I don't care if it's 900,000, that balance is completely exempt for Medicaid purposes. Sadly, at least a half a dozen occasions, families have called me after they've already liquidated hundreds of thousands of dollars that were in IRAs because they called their financial advisor and didn't call us when the crisis hit. So do yourself a favor. If there's any kind of crisis, yes, let the financial advisor know, but call your attorney before you do anything. Okay. And it's not on my list of top mistakes, but one of the biggest problems that we do see is seniors buying annuities. So talk to your elder law attorney before you purchase any annuity products. Okay. Which I don't have time with today's talk to get into that, but they can be a real gotcha and a big no-no under the Medicaid rules. And I'm just going to make the plug. There are other really great programs as part of Information and Inspiration that are being put on this month. So do yourself a favor and check them out, because there are other programs specific to Medicaid that I can't address today, but it's all part and parcel. All right. So number 2 of the common mistakes is failing to protect a sick spouse. All right. Traditional planning that we see with most people is, if I pass away, I give everything to my beloved spouse, right? And that's typical. It's great, not great, but it works out perfectly if your spouse passes away. However, if a spouse becomes disabled and the will isn't changed, it can be catastrophic. And why is that catastrophic? Well, you met with the elder law attorney, you moved assets into the well spouse's name, and now the well spouse suddenly passes away. Well, if you have that sweetheart will and it says everything goes to my beloved spouse, you just inundated that person with assets, and now they don't qualify for Medicaid anymore. So you owe it to yourself, if you're sitting down and doing any kind of planning and you're filing a Medicaid application and you're a spouse, you want to update your will, because what you can do is actually include a supplemental needs trust under the well spouse's will. So what does that look like? All right. First of all, again, I love financial advisors. They're some of my best colleagues. I love working with them. But if you only talk to them, very often they'll say, oh, well, we just won't name that ill spouse as a beneficiary. You don't want to do this. In New York, we actually have a law that addresses this. You're not supposed to disinherit your spouse. And the Medicaid program, caseworkers and supervisors and attorneys all know it. They're very conversant with it. And they will come if the well spouse passes away and say, okay, the person on Medicaid is entitled to what's called their elective share. Where is it? And if you have inadvertently or purposefully done planning that avoids paying that elective share to the surviving sick spouse on Medicaid, they will be treated as though they made a disqualifying gift, lose their Medicaid, and there'll be a penalty period. So you want to make sure that the planning is set up properly. Okay. So whenever possible, remember I said a couple minutes ago, funds inside an IRA are completely exempt if they are in pay status. So if you're the well spouse and you have an IRA, you still name your spouse who's on Medicaid or going on Medicaid as your primary beneficiary. The reason is because if you pass away first, that spouse who's on Medicaid can roll over the IRA, continue simply taking distributions on an annual basis, and whatever's left can have the beneficiaries named via that power of attorney that you updated to your adult children, your favorite charities, your sister, your brother, your neighbor, whoever it is. But that's a perfect way to satisfy that elective share. Okay. And then for any probate assets, because of course, as part of the Medicaid application, the accounts all went into your name individually. Now you can name a supplemental needs trust that you create under your will to hold all of those other assets, so that when the needs arise that aren't covered by Medicaid, because it essentially pays room and board at the nursing home or is paying for aides to come into your home, you still are going to need funds, or your loved one, your spouse, is still going to need funds to cover other supplemental expenses. So that's a really elegant way to take care of it, still satisfy the elective share, and it still benefits everyone. No, it's not best to transfer IRAs to Roth IRAs. It depends on your individual circumstances, because when you convert a traditional IRA to a Roth IRA, you've got to pay income taxes on it. So yes, it's a great idea if it fits for your unique situation, but for Medicaid, it's not going to make a difference, because you will still have to take out distributions as if it's a traditional IRA. The tax rules are completely ignored in the Medicaid context. So a lot of people think if they roll over into a Roth, they don't have to worry about taking distributions, but that's not the case. So it could be really good to use a Roth, but it's not going to do anything for you in the context of Medicaid. Okay. And then the other thing I like to talk about, remember I mentioned before that there were trust mills operating here and around the state where folks were sort of scared into using a living trust as their planning tool. Under federal law, it's specifically prohibited that you cannot set up a trust for your spouse, a supplemental needs trust for your spouse via a living trust. It has to be testamentary, has to be under the will. It's a really odd, arcane piece of the legislation, but it's there. So you need to know who you're working with, and you need to know that it's an elder law attorney who understands these provisions, because sadly, I've seen living trusts that set up supplemental needs trusts for spouses. And they weren't set up by elder law attorneys. They were set up by someone who, found a form and cobbled something together and thought they were doing something great and charged a lot for it, but they weren't an elder law attorney. And luckily, the last time that this came up, we were able to fix it before it caused irreparable harm, but you need to be careful. Okay. So here's the example of that sick spouse. All right. Again, John and Jane, not the same ones from before. They have sweetheart wills. Jane goes into the skilled facility. SNF stands for skilled nursing facility, and she applies for Medicaid after transferring all but her allowable $15,900 to John. He dies suddenly. If the assets pass to Jane outright, and her family then will need to negotiate with the county wherever she's receiving her benefits to be able to try and maintain them, and a lot of that inheritance is going to be lost. Option two, have seen this come up. John spoke to a financial advisor who wasn't an attorney, who recommended changing all of the beneficiaries to the adult children. The caseworker notices this and says, you should have named Jane for at least her elective share amount, which is $50,000 or 1/3 of the net estate. So that's the net taxable estate, doesn't include life insurance. And so deems the value that went to everybody else other than the life insurance as an unqualified transfer, and she loses her Medicaid coverage. These things happen on a regular basis, and it's not obviously intentional. The financial advisor had everyone's best interests at heart, but they're not attorneys. They don't get training in Medicaid. They have to know about investments and finance laws. They don't understand Medicaid. They don't have time to learn it. And that's why we have to work as a team together. So the easiest thing to do if you're facing anything is to set up a mandatory S&T under your will for your spouse who's suffering from a disabling condition. Or if neither of you are hopefully having any health issues, then when you update your planning, put in what's called a standby supplemental needs trust. So your will can still say, I leave everything to my beloved spouse, except if they're disabled at the time that I die, Then their share under my will goes into the trust that's in article whatever. So you've set it up as a proactive measure. It may never get used, but it's there. It's a safeguard, and it's really easy to incorporate, and any elder law attorney knows how to do it. Okay. Mary Rose, I'm trying to go back up. I see questions. During the spend down period until resident in nursing home qualifies for Medicaid, who pays if the resident doesn't have the money? You have to pay the estimated NAMI, and that's why I'm telling you, you want to be working with a licensed elder law attorney. This is not DIY work, okay? And granddaughter says the money has been spent, so she has none left. Well, the granddaughter may have engaged in fraudulent conveyances and may find herself sued. And it happens. All of our local nursing homes are represented by very skilled attorneys. I can tell you that Harris Beach has a collections group that works for nursing homes across the state. And I am frequently consulted by them to review these situations when folks have applied for Medicaid, but done some self-help planning. And we go in and I know exactly what to look for. So I can tell the nursing home and the creditors' rights attorneys what should have been done properly if they were working with a reputable elder law attorney, and if in fact they weren't. And it's really, really easy. And I can tell you that in town, there is a list of attorneys who are elder law attorneys, but the nursing homes do not trust them. And if they see their name on an admissions application, it's much harder for their clients to get an admission. So you want to be working with someone reputable who has a really good track record of getting their clients approved. And you want to make sure that you're asking them how to figure out how much to pay every month. If you're in a spend down phase and the money is already gone, something happened. Something happened. Doesn't sound right, doesn't smell right to me. Life insurance premiums still need to be paid. Is that allowed? Life insurance premiums are going to have to be paid out of the retained $15,900 that the applicant is allowed to keep for Medicaid. Okay. And then finally, here's, as I mentioned before, the preferred method. If John would have worked with an elder law attorney, he could set up everything that's going under his will to that SNT, Supplemental Needs Trust for Jane. I'm not sure, and if you're still watching, if you want to post in chat, if you have specific questions about Supplemental Needs Trust, but the idea behind them is that the Medicaid program cannot force the assets in this trust to be accessed by the trustee for the benefit of that person with disabilities. It is a true safeguard so that those assets can be used during their lifetime. And if it's a third-party trust, such as a testamentary one that you create under your will, when Jane or whoever the beneficiary is passes away, you have included within your will terms who ultimately inherits those remaining funds. So it's a good way to safeguard assets to stay within a family while still protecting a loved one. I'll call it the old school way would be to say, well, I'm not going to leave an SNT for my spouse. My kids can take care of her, or my kids can take care of him. I'm not a fan of that because invariably, if there are multiple children, they all have their own needs. Typically, they have their own families, they have their own financial issues. And what ends up happening is, one person will probably end up having to go out of pocket to take care of mom or dad. And then there's a lot of resentment that builds up among the siblings. And there was probably resentment long before, the other spouse passed away. So creating a supplemental needs trust also helps with family relations because there's that pot of money that can be dipped into for the surviving parent or the other surviving, whoever it is. And ultimately everyone shares equally. So just for practical purposes, I think it's a really good idea to include that. Okay. And then the big benefits with this, right? The IRAs, again, I can't stress this enough. IRAs get special treatment. And I do want to point out IRAs are different from other retirement accounts. Under the Medicaid rules, a 403B or a 401k, other arrangements, they don't get that protection. The account has to be rolled into an IRA, and you have to be taking distributions from the IRA for the balance to be considered exempt. Okay. And then again, if you've got a good comprehensive power of attorney, whoever is Jane's agent after John passes away can then update the beneficiaries as part of the rollover process to name the adult kids or whoever else should be inheriting. So it flows very nicely, but that's where I can't stress enough, review, and update as needed. We can talk about, so fees are going to vary depending on who you're working with. The more experienced attorneys charge more, but you should expect to spend a few $1,000s for a basic, straightforward plan that includes wills, powers of attorney, healthcare proxies. And if you do additional planning like an asset protection trust, then yes, the fees go up. But what I always tell folks is, you're not paying realtors commissions, and you're still safeguarding in most instances an asset that's worth multiple six figures. So we'll talk about that as we get into this. Using a life estate deed instead of an asset protection trust. Okay, so I mentioned before, living trusts are revocable. You can reach in and access your assets inside of them. That means that your creditor, including any place where you're receiving care, such as a nursing home or an assisted living facility, can reach in. Those assets will never be protected. So if you're trying to do asset protection planning, we need to use an irrevocable trust. Okay. Simple deeds that transfer what's known as a remainder interest in real estate, and usually it's your primary residence, but it might be a vacation home, while holding onto a life estate in the original owner, are really dangerous. The reason is that we don't know what's going to happen. And when you just start adding people onto a deed, they are now all owners. All. It's not just you and the kids will someday have an interest. No, once you put their name on, they are now a co-owner with you. So there are times that we don't recommend using an asset protection trust. Okay. If we already know that someone has a condition where they're likely to deteriorate or need a high level of care, such as in the nursing home in the near future, we really don't want to get into creating a trust, because when you talk about nursing home Medicaid, or what's referred to as chronic care Medicaid, there's a 5-year look back. Most people have heard of that. And any gifts that have been made within that 5 years, such as creating and funding an irrevocable trust because you gave up ownership, that's a gift, all are part of that look back. And the Medicaid caseworker will say, well, what went into, what was the total number or value of gifts? And it's divided by what's called the regional rate. So our rate here in Rochester is a little bit more than $13,000 per month. Remember I said the actual cost of a nursing home is upwards of 14, very often 15 or 16. The caseworker will say, for every $13,000 that you gave away, that's 1 month that we won't pay the nursing home, and you have to pay the private pay rate. So if we know that someone might need to go on Medicaid in the near future, we don't want to create one of these trusts. But we also don't want to do a life estate deed either, because it's the same thing. The value of what you give away is going to get pulled back in and penalized if there's an application within 5 years of that gift having been made. Okay. The other key piece with this is that I keep saying how it's so wonderful that IRAs are exempt assets as long as they're in pay status. Well, the admissions directors at the nursing home and the finance folks know that. They understand these rules. So if you transfer your largest asset, your residence, into a trust, and you have an IRA, but you don't have liquid assets like checking, savings, non-IRA investments, cash inside life insurance, around Rochester, most of the nursing homes want to see a minimum, if possible, of $150,000 in liquid assets outside of the IRA. If you don't have that, you're not, in my opinion, a good trust candidate. I tend to be a little bit on the conservative side. I admit that. Some other elder law attorneys might be a little bit more aggressive. I've worked with attorneys in the past who still recommended people put all of their assets into a trust. I would never recommend that because, again, look back period, and you want liquid assets to show the nursing home that you are able and willing to private pay for a time. They need to be paid for the care that they're providing. They're not the bad guys. I understand that, none of us really want to be in a nursing home. We want to be home. We want to be with the people we love. But if you find yourself in that situation out of necessity, you want to make sure that they're getting paid. Okay. No, irrevocable trust can't be modified. There are provisions under our statutes that allow for revocation. And we do have something called a decanting statute. But again, it's not something DIY, and you need to be working with a skilled attorney. The whole idea behind an irrevocable trust is that it is supposed to be irrevocable, because unless you give up control and ownership of the assets, they're not protected. They will be available to be used for care. So what are the big cons with using a life estate deed? We talked about the look back and a penalty already. But here's the thing. If you do one of these deeds and transfer the remainder interest and keep a life estate, depending on how long you've held that property, if you sell it during your lifetime, your kids aren't using that property as their primary residence. They may have to pay capital gains taxes. Most of the folks who have the life estate won't have to worry about it because it has been their primary residence, and they'll get the capital gains exclusion under the tax code. But those remainder interest holders, unless they're living with you, they don't get that exemption. This is the one that bothers me the most. The real estate could be lost to creditors if your adult child goes through something like a bankruptcy or gets sued. As a young associate many years ago, I was working at a small firm where one of the local bankruptcy trustees worked. And I'll never forget him coming down the hall into my office and saying, I need you to check the county clerk and then find this lady's number, back when we still had white pages where everyone used them. And I had to call a lady up in Arundecoit who was in her early 80s. And I introduced myself and I said, is your son John Doe? And she said, yes. And I said, do you know if your son John Doe is in bankruptcy? And she said, yes, unfortunately he is. And I said, oh, I'm sorry to hear that that's the same person, because unfortunately for you, you put him on as a remainder owner, interest holder on your home. That is now an asset of his bankruptcy estate. So we're going to need you to buy back his interest that you gave him, because he needs to pay his creditors. Wasn't his primary residence. He had no exemption on that property. So here's this lady who was trying to safeguard an asset, and it ended up completely being a disaster for her. And then this one can sometimes work out, but it's usually not what anyone would want. If you put an adult child on and they're married, if they predecease you, guess what? Their interest in your property passes through their estate. So you could end up owning property with your son-in-law or daughter-in-law accidentally. And again, maybe that's fine. Lots of families are very close to their in-laws, but not all are. And that may not be what you really intended to happen. So you got to be mindful of the consequences. And I can't tell you how often people enter into these transactions saying, oh, I just need to safeguard the house and I don't want to pay for a trust. I don't want to have to pay anything expensive. I'll just call the real estate attorney and have them do a new deed. But no one ever has these conversations about what could actually happen. You need to understand the what ifs. And if you understand the what ifs and you're comfortable with it, well, then you can take that chance. But we do not recommend these types of deeds, because too often we are trying to deal with the cleanup. Okay. So here's an example. And this is what I was just talking about. Ted didn't tell his mother he was having financial difficulties, so she put him on the deed, and then he files for bankruptcy right after that. If she had created an irrevocable trust, it avoids all of these problems, because once that asset goes into the trust, I mentioned before, you can't use a revocable trust and be protected against creditors of your own. But with an irrevocable trust, if you put the asset in, it protects you against future creditors, future, not existing, future creditors, but it also protects your beneficiaries. They can't reach through and touch any of the assets in the trust. So it's phenomenal protection for your adult children to use a trust. So it safeguards the asset and it protects them against some of, the worst life events that can happen. Okay, so what are the fixes to these major mistakes? If it's a faulty power of attorney, get a new power of attorney, or else you might be facing an Article 81 guardianship proceeding. They're not ideal, but there are really skilled elder law attorneys in town who handle them. So it's not the end of the world. It's just unfortunate if you wind up in that situation. Okay. If you fail to protect a sick spouse, ideally, you're going to have the time to update the will and do planning for both spouses. If you find yourself in a fix, call an elder law attorney to help you negotiate with the county so that you're not simply writing a large check and walking away. And using a life estate deed, depending on when the deed was created, if it's already happened, evaluate it and determine if maybe a corrective deed should be done, going back to the parent who first did it, and then see if you're a candidate for using a trust. There are always options if you're still able to sign and meet with someone. But if you do nothing else, pull out your planning and review it. Make sure you have a comprehensive power of attorney. Make sure you have beneficiaries named on your IRA and any of those other accounts that have beneficiaries to be named. And sit down with a qualified elder law attorney. You don't want to just use a general practitioner for these matters. They're too important. The assets that you're protecting have too high of a value. So with that, I want to thank you for attending. I gave you my number before. It's here again. That is my direct dial. It's my confidential voicemail. I'm going to stay on because we still have some time to take any additional questions. And yes, Mary Rose, there is a satisfaction survey that you can take. The link is there in chat. And Mary Rose, I don't know if you're coming back on, but I want to make sure I highlight that Lifespan is celebrating 50 years. If you are so inclined, making a gift, we have a very generous match and it will double your impact. If you are able to do that, you can Venmo, you can see it up there at Lifespan-Rocked. You can send your cash or check to Lifespan. You can donate online. There are many, many options there. Okay. Oh, great. There you are, Mary Rose.
I am here.
Sure, I didn't talk over you. I'm not seeing any other
questions.
Oh. Does Lifespan have a list of recommended financial planners? I don't recall ever seeing that, Mary Rose.
No, we don't have that one.
Okay.
It's a little bit above our pay grade.
Yeah. But Bill, if you're working with an elder law attorney, they will have people that they work with who they vetted and who they trust, who aren't going to steer you in the wrong direction. My telephone number again. Here, I'll put it. My telephone number is 419-8869. Can you rescind a life estate deed in order to sell property and get capital gains benefit? It's a maybe. Depends on if the parties are still alive. If everyone's still alive, you can always, engage in some planning after the fact. I went through this recently with a family where they had included their son about 8 years ago. And he said, I don't want to be on this deed anymore. I am engaged in some high risk investments and things, and I travel a lot for work. So he gave the property back to his parents, and they're in the process of doing some other planning. That one was out of the ordinary for me. But if people are still available, there are always options. The question about paying life insurance. If you're paying, let me back up. if you're paying life insurance premiums for someone who is going through the Medicaid process or is already on Medicaid, you have to pay those premiums out of their retained assets because their income has to be used for their care once they qualify for Medicaid. Otherwise, I know after someone's been on long enough, if their resources dwindle, usually family members who are the beneficiaries of that life insurance policy or those policies will pay the premiums because they're ultimately going to benefit from it. And then Bill's asking, what are appropriate uses of living trusts? Well, that's where I was talking about for privacy concerns. If you do not have a spouse and children, the people who, if you only have a will-based plan, are your distributees are entitled to copies of your will and notice of the proceeding. So if the people who would inherit from you, if you didn't have a will, are, far-flung relatives that you have no contact with anymore, you may want to use a living trust to avoid them having to be tracked down and find out who you actually left your assets to at the appropriate time. It can save on a lot of costs doing that. And I had something, oh my gosh, probably about 1.5 years ago, where a gentleman did use a living trust. I wasn't the one who drafted it. And when all was said and done, we ended up finding some assets that weren't in the trust. They came to us for the administration piece, and we had to do a probate for those few accounts we found. And we had to hire a genealogist to do research because there was so little in his records, and we had to do it's called service by publication, where we had to publish in the last known vicinity of one of his living relatives, and that cost a couple $1,000s. It was really frustrating. So I mentioned that. And then if you own out-of-state property, very often it's useful there to avoid duplicate court costs, because you've got to go through a court proceeding in each state if you're using a will-based plan. Okay. Oh, you're very welcome, Barb. So those are the main ones: privacy and avoiding duplicative court costs. Okay. So, and then for a lot of folks, they just like the management aspect of it. It keeps things private and it's very smooth. You don't have to wait for someone to be appointed by the court. But in New York, it's certainly upstate. Most of our courts can get someone appointed within a couple of weeks if everyone who needs to be served and sign off on the appropriate waivers and consents gets them in quickly. So.
All right. Thank you, Lisa, so much. It's a complicated topic. And because it is so complicated, we have one other legal workshop coming up next Tuesday on the 16th. Legal aspects of caregiving. If you still have questions or concerns, you can certainly register to join that one. And we want to thank you for joining us today.
Thank you, everyone. Thanks, Mary Rose.
Thank you, Lisa. As always, very informative.
Oh, thanks very much. Have a wonderful evening.
Sure.
Thank you. Thank you very much. It was very good.
Thank you, Janice.
Thank you.
Thank you, Janice. Bye-bye.